Hello everyone. In this lecture, let us understand what a presumption means. As in daily life, we often assume things based on common sense. For example, if we see dark clouds in the sky, we may assume that it may rain that particular day, and we are not completely sure. But based on experience, we make a logical guess. In the similar manner, courts also do something similar. In law, this idea is called a presumption. A presumption simply means a conclusion that the court can draw from certain known facts. Section 114 of Indian Evidence Act says that the court may presume certain facts by looking at the common course of natural events, human behavior, and normal business practices. Let me explain why this rule is so important. In many cases, the court may not have direct evidence for every small facts. If courts insisted on strict proof of everything, many cases would become impossible to decide. So the law allows judges to use common sense and probability. Let us take a simple example. Suppose a theft happens and very soon after the theft a person is found with stolen goods. In such a situation, the court may presume that the person either committed the theft or received the goods knowing that they were stolen. This is because normally people do not suddenly get stolen property immediately after a theft without some connection to the theft. But remember something important, a presumption is not a final proof, it is only a probable conclusion. If the person gives a reasonable explanation, the court may reject the presumption. So, the main idea of Section 114 is that courts can rely on logic, probability, and normal human behavior when direct evidence is not available. Now, let us understand three types of presumptions recognized under the Evidence Act. These are may presume, shall presume, conclusive proof. It is very important to understand that the difference between these three. First, let us look at may presume. When the law says the court may presume, it means the court has a choice. The judge may accept the presumption or the judge may ask for more proof. So, nothing is compulsory in may presume. Section 114 mainly falls under this category. For example, if stolen property is found with a person, the court may presume involvement in the theft, but the judge will still look at the circumstances before deciding. Now let us move to shall presume. This is stronger than the previous one, that is may presume. When the law says shall presume, the court must accept the presumption unless the opposite party proves that it is wrong. So here the burden shifts to the other party to disprove the presumptions. An example is section 114A, which we will discuss shortly. Finally, we have conclusive proof. This is the strongest category. When the law says something is conclusive proof, the court must treat that fact as final and no evidence can be given to disprove it. So remember this simple order. May presume means court has discretion. Shall presume means court must presume unless it is disproved by the opposite party. Conclusive proof means it is final and cannot be challenged. This distinction is very important and we should be remember always. Now let us look at the illustrations given under section 114. These illustrations are very important because they show how presumption work in real situations. Let us first understand illustration A. It says that if a person is found in possession of stolen goods soon after a theft, the court may presume that the person is either the thief or someone who received the goods knowing they were stolen. The reasoning is based on a common sense. Normally, an innocent person will not suddenly get stolen property immediately after the theft. But remember, this is only a may presume situation. If the accused gives a reasonable explanation, the court may reject the presumptions. Now let us look at illustration G, which is also very important. This illustration talks about withholding evidence. It says that if a person has important evidence but does not produce it in the court may presume that the evidence would have gone against that person. For example, suppose a company has account books that are important for the case, but the company refuses to show them in the court. In such a situation, the court may presume that the records would have damaged the company's case. This rule discourages people from hiding evidence. There are several other illustrations also, such as official acts are presumed to be done properly. Business transactions are presumed to follow than the usual course. Letters are presumed to reach their destination in normal life. All these illustrations are based on normal human behavior and practical experience. In the slide, let us understand section 114A, which deals with presumptions in certain rape cases. This provision was introduced to strengthen protection for victims. Earlier, it was often difficult for the victims to prove that there was no consent. The accused could simply claim that the act was done unconsensual. To address this problem, the law introduced section 114A. According to this section, if sexual intercourse by the accused is proved and the woman states in a court that she did not consent, then the court shall presume that there was no consent. The word shall presume are very important. This means that the court must accept the absence of consent unless the accused proves otherwise. So, in such cases, the burden shifts to the accused. The accused must produce evidence to show the consent actually existed. For example, the accused may try to show circumstances or communication suggesting voluntary participation. However, remember one important point here. Section 114A applies only after the prosecution first proves the sexual intercourse occurred. So, the prosecution still has an initial burden. Once that fact is established, the presumption about consent will arise. In this slide, we will understand rebuttal of presumptions. Most presumptions under the Evidence Act are rebuttable. This means the opposite party has a chance to disprove the presumption by giving evidence. A presumption does not permanently decide the case. It only shifts the burden temporarily. Once a presumption arises, the party against whom it operates must give an explanation or produce evidence. The strength of rebuttal may depend on the type of presumption. In may presume cases, even a reasonable explanation may be enough to avoid the presumption. But in shall presume cases, stronger evidence may be required to disprove the prosecution. Let us take an example again. Suppose a person is found with stolen goods soon after theft. The court may presume his involvement, but the accused may say that he bought the goods from a shop without knowing they were stolen. If this explanation is supported by the evidence, the court may reject the presumption. Similarly, section 114A, the accused may try to rebut the presumption by producing evidence suggesting consent. So the important point is to remember that presumption do not remove the need for evidence. They only shift the evidential burden from one party to the another party. In this final slide, let us quickly revise important points about presumptions. The first one is presumptions help courts reach a conclusion when direct evidence is not available. They are based on logic, probability, and normal human behavior. Second thing, remember these three types of presumptions, that is, may presume, court has discretion; shall presume, court must presume unless disproved; conclusive proof, final and cannot be challenged. Third point is presumptions are closely connected with the burden of proof. When a presumption arises, the burden shifts to the opposite party. For example, if a person is found with stolen property, the burden may shift to him to explain possession. Similarly, under section 114A, the burden shifts to the accused to prove the consent. So in this video we need to remember few common course of events, that is human conduct, may presume, shall presume, rebuttable presumption. If we understand these ideas, we will be able to answer both theory and problem based questions in the Indian Evidence Act. If you found this video helpful, please like, share and subscribe. Thank you for watching.